Hello, and welcome to another Help for Homeowners webinar session. I am Clemente Mejia, and I supervise the Foreclosure Prevention Program at the Department of Consumer and Business Affairs. This week, we'll be discussing foreclosures of junior and non-mortgage related liens. Since the termination of the CARES Act, the federal agencies continue to extend their moratorium on foreclosures and evictions in order to curtail homelessness for millions of Americans who continue to struggle financially due to COVID-19. However, nearly half of the mortgages in Los Angeles do not qualify for these protections, and California law only grants them the ability to inquire about a forbearance plan. Homeowners who currently have a forbearance plan will continue to forbear payments until the end of their term, and some may be able to extend the forbearance period for a total of 18 months. However, others may not be afforded an extension, and they will have to work with their lender on a repayment plan or potentially modify their loan. Also, junior liens and liens for unpaid homeowner association dues and property taxes are legally able to proceed with a foreclosure. Next slide. Oh, I'm sorry. We can stay here. So the Los Angeles County Department of Consumer and Business Affairs has been serving Los Angeles County consumers and businesses since 1976. The mission of the department is to promote a fair and vibrant marketplace. We serve consumers, businesses, and communities through education, advocacy, and complaint resolution. Next slide. Today we have two experts who will tell us more about the foreclosures of junior and non-mortgage related liens and where homeowners can get free, reliable help. From our foreclosure prevention unit, we have a senior foreclosure prevention counselor, Samuel Luquin, and we also have Leti Andrade. Next slide. Before I turn it over to the presenters, just a reminder to our participants, please keep your mics muted and use the chat box to submit your questions. Next slide. Okay. And I'll hand it off to our presenters now.
Thank you, Clemente. Today we're going to cover the California foreclosure process, deed of trust, other types of liens, lien priority, protections, and limitations. Next slide. What is a foreclosure? A foreclosure is the legal process used by lenders to recover the balance of a loan that is secured against a property when the property owner fails to meet the obligations of the loan. Most people buy a home by borrowing part of the purchase price, usually from a bank or mortgage company. When a homeowner fails to make the payments due on the loan, the lender can foreclose, which means that the lender can force a sale of the home to pay for the outstanding loan. Now, there are two types of foreclosures. There's the judicial foreclosure, which involves filing a lawsuit to get a court order to foreclose on the home. It's used when there is no power of sale clause in the deed of trust. It usually involves a borrower and a lender. After the court orders the sale of your home, it will be auctioned off to the highest bidder. Now, a non-judicial foreclosure is the most common type of foreclosure in California. It is used when there is a power of sale clause in the deed of trust that secures the mortgage loan by giving the trustee the authority to sell the home to pay off the loan balance at the request of the lender. No court proceedings are necessary with a non-judicial foreclosure. Most lenders opt to use the non-judicial process because it's quicker and cheaper than having to go to court. Next slide. When a lender loans money to someone to buy a home, it usually requires that the obligation be secured by a mortgage or deed of trust on the real estate that the borrower is buying. Most deed of trust will have a power of sale provision in the loan contract. It is the clause in which the borrower pre-authorizes the sale of the property by way of non-judicial foreclosure to pay off the balance of the loan in the event of a default. General information that a deed of trust must contain are the borrower's name, the lenders, the trustee, and it should also contain the legal description of the property. The power given to sell the property is generally given to the trustee, who acts on behalf of the lender by recording and sending notice of default and notice of sale. The trustee only comes into play if you fall behind in loan payments and go into foreclosure. Some of the most common documents with the power of sale are purchase money loans, refinances, which is when you refinance your mortgage, your bank or lender pays off your old mortgage with a new one, hard money loans, which are usually short-term financing, and reverse mortgages, which you have to be 62 years old to qualify, and you are required to pay property taxes and homeowner insurance. If you default, you run the risk of getting foreclosed on. Next slide. People who live in a house, condo, or townhome that's part of a common interest development in California are usually responsible for paying dues and assessment to a community association, like a homeowners association or HOA. If you don't make the payments, the HOA can get the lien on your property that could lead to a foreclosure. Almost all HOAs have the power to place and record a lien on a property if the homeowner becomes delinquent in paying the monthly dues and any special assessments. A common misconception is that the HOA cannot foreclose if you're still paying your mortgage, but the HOA's right to foreclose has nothing to do whether you're current on your home loan payments. HOAs can begin to foreclose as soon as an owner owns $1,800 in dues. Foreclosures can be judicial or non-judicial. If the HOA forecloses using a non-judicial process, the foreclosure is subject to a 90-day right of redemption after the sale. To redeem the property, you must pay all assessments, interest, and attorney fees. Next slide. Another type of lien that has a power of sale are defaulted tax liens. Unpaid property taxes for a minimum of 5 years become subject to the county tax collector's power to sell the property. In order to satisfy the defaulted property taxes, the treasurer and tax collector's office can sell your home. Before the sale, notifications is required to be sent to the homeowner and any other party of interest, informing them of the treasurer and tax collector's power and intent to sell the property for non-payment of taxes. All defaulted taxes must be paid in full by the last business day prior to the date of the public auction. If the tax is not redeemed, the treasurer and tax collectors has the power to sell the property. The state controller's office administers the property tax postponement program. It allows eligible homeowners to postpone payment of current year property taxes on their primary residence. A postponement of property taxes must be eventually repaid. To qualify, one must be at least 62 years old or blind or disabled, own and occupy the property as his or her principal place of residence, have a total household income of $45,000 or less, have at least 40% equity in the property, and not have a reverse mortgage on the property. For more information about this program, you may contact the controller's office at 800-952-5661. And for now, I'll be passing it over to Sam now, as he is going to be discussing the importance of lien positions. Thank you.
All right, thank you, Lady. Hi, everyone. My name is Sam. I'm a senior foreclosure prevention counselor with the LA County Department of Consumer and Business Affairs. I want to talk to you guys a little bit about lien priority in California. Priority rules are actually set to establish a superior and subordinate status when two or more liens are recorded against a property. Liens can actually be established in two different ways. You can have a consensual lien, for example, a deed of trust when you purchase a property, or borrow money with the intent to pay it back, or non-consensual. Maybe somebody sued you, or as an example earlier, an HOA put something against your property because you didn't meet your obligations. Now, timing is actually going to play a large role in position, and we're actually going to talk about position, why it's important in a couple of seconds. But timing it plays a big role because it actually is going to decide whether or not you're going to qualify for certain programs that have been offered or will be offered in the future. California's basic rule of priority is priority with consensual liens is essentially it comes to the time of creation. So if a deed of trust is dated and signed off on, let's say July of 2018, that deed of trust will have priority over a deed of trust signed and completed in August 2018. So the timing is really going to put a lien over another one. The best way to really make it known that a lien has priority and what's most commonly used is when a deed of trust is recorded with the county recorder's office. The recording helps secure, although it doesn't absolutely guarantee position, but it does make it known to the world that there is a deed of trust with a certain date and time. Next slide. So a common misconception, and I think right now there's been a lot of bad information surrounding the current foreclosure moratorium, is the foreclosure of multiple liens. So when a property does have multiple liens with a power of sale, in reality, every lien is going to have the right to foreclose despite the position. It is a common misconception that junior liens or subordinate liens, for example, second liens or thirds, that it's a common misconception that they cannot foreclose. Unfortunately, we do hear a lot of people say that they were told that they had a second lien that's starting the foreclosure process, but they've been, current on their first mortgage or their first loan. And unfortunately, the second lien would in fact have the power to come back and start the foreclosure process despite the first loan being current. Now, if a superior lien, or for example, the first lien were to foreclose, any junior liens subject to them, subject to the foreclosure, would actually be wiped out, or at least their security instrument would be gone. That doesn't mean that the actual debt is no longer owed. It's possible that they could sue somebody else using the promissory note that's signed when the deed of trust is originated, or it's actually most likely that that second lien holder or the third lien holder would go after any excess proceeds from the foreclosure sale that took place from the first. Next slide. Okay, so why is this important? Like I said, so like Clemente had mentioned in the beginning, the CARES Act actually placed a foreclosure moratorium for all loans which were federally backed. Now, these federally backed loans include government-sponsored enterprises like Freddie Mac and Fannie Mae, FHA loans and HUD, which is Housing and Urban Development, VA or USDA loans. Those temporary forbearances were extended, and they were also allowing property owners to request forbearances should during that time they run into an issue related to COVID affecting their financial situation. The forbearance extensions have actually been pushed out to be requested at the end of June of this year. It's important to understand, well, before we get into that part, every loan right now, or every federally backed agency or government federally backed loan has different rules. It's going to be very important for you to sort of contact your servicer when you do run into trouble, or contact a reliable source of information to really understand what it is that you're entitled to. Now, the other idea too here is that it's important to understand that the current laws and the current protections, they won't last forever. They are ending. There hasn't been any legislation showing that they are going to be extended yet. That doesn't mean it's not going to happen, but I think it's we really don't know right now. Next slide. Now, a lot of people were wondering, well, I have a mortgage and I have a first loan, and but it's not backed by it's not federally backed by the government. Why don't I qualify for these same protections? Well, AB 38 in California developed the Small Landlord and Homeowner Relief Act. This act came about in August of last year, and it required lenders to review certain property owners for a temporary forbearance, just like the CARES Act did. However, the CARES Act did have the moratorium for foreclosures. This did not develop the moratorium. It simply required certain steps to be taken when a property owner who had a first lien was requesting temporary or a forbearance. The bill applied to, like I said, liens who held the first position, which is why we went over lien superiority. It applied to properties with 1 to 4 units. And something unique to this bill, which really wasn't there in the past for protections, was the property didn't actually have to be owner occupied. If the person was a landlord and they owned another property that was maybe 1 to 4 units, they could apply the same requests as if they had lived there. Next slide. In addition to that, property owners were required to be current on their mortgage as of February 1st of 2020. And they were also required to prove how they were actually financially impacted by the COVID-19 virus. This was sort of, it's a little nebulous when the language comes up. And that's why we always encourage somebody to really reach out to their servicer and ask what exactly is going to be required to prove, to show that I was negatively affected. When this request for forbearance comes in, the lender was now required to give actual details as to why they were denied if they were. If they were denied, they were required within a certain time period, I believe it was 21 days, to provide the details as to why they were denied based on not qualifying, or maybe it was even something as simple as you didn't fill out one portion of the form. That was actually giving the property owner the opportunity to appeal or resubmit with the correct information to be reevaluated for a temporary forbearance. In addition, lenders were also required to discuss what's called post-forbearance options with the homeowner. So around 30 days before your forbearance was scheduled to end, lenders were required to reach out to property owners and go over with their financial situation and decide or help them look at what options might be available to them, moving forward. Okay, next slide. Now, why we're mentioning this is because we're not necessarily sure that these programs that were protecting people during these hard times were going to continue. Recently, the California COVID-19 Rent Relief Fund was established. This fund was available to landlords as well as tenants through what's called SB 91. The bill allocated $2.6 billion to eligible households. Now, however, the uniqueness of this program is it required tenants and landlords to work together. For example, if a landlord were to call the telephone line and say, I have a tenant, they would have to get in touch with the tenant and come to an agreement. Typically, the state or the relief fund would be willing to pay off 80% of the past rent in exchange for the landlord forgiving the other 20%. Landlords are actually encouraged, as well as tenants. Tenants can begin the process too, to apply online at housingiskey.com or call the telephone number here, 833-430-2122. Next slide. More recently, the Los Angeles County Mortgage Relief Program was established. Now, the Los Angeles County Board of Supervisors passed a motion to create a new mortgage relief program available to property owners. The program is actually providing direct assistance to property owners who qualify up to $20,000. Residents of the County of Los Angeles are actually going to be provided or are going to be eligible. Unfortunately, residents of the City of Los Angeles are actually ineligible. The property itself must be owner occupied. It cannot contain more than 4 units. They are going to require that the property owners receive counseling from a HUD approved agency or a HUD approved counselor. The telephone number that you can contact directly is 888-895-2647. Next slide. So a lot of the programs that are here are very specific to certain individuals or certain landlords that are facing very particular situations. The LA County Department of Consumer and Business Affairs does have a foreclosure prevention division. Now, this division is actually set up to help anyone who is facing foreclosure as long as the property is 15 units or less. Now, as we went back and we talked originally about the programs and who qualifies, and it's not just first liens that can foreclose. We looked at, Letty mentioned a homeowners association can foreclose, a second lien can foreclose. You could be sued and they could get the power of sale. Our program is really set up to make sure that the proper applications of the laws when it comes to foreclosure and the actual guidelines of the loan are followed correctly. It's a free service that the department offers. Again, I can't stress this enough. Everybody's situation is different. We recommend that no matter what happens, if you're looking at foreclosure, even if it's brand new, you give us a call and we can kind of direct you and guide you to the best source that's going to be able to help you. Next slide. So for our department, you can actually contact us a couple of different ways. The first one would be email, and it's listed there, homehelp@dcba.lecounty.gov. You can call us by phone, which is usually, I mean, me personally, I think it's the easiest, at 800-593-8222. Or you can go to our website. Our website is dcba.lecounty.gov/foreclosure-prevention. Next slide. Okay, do we have any questions? I think we're going to open it up to the question portion.
Yes. Hi, Sam. So yeah, we do have a couple questions, and also for our participants, if you have any questions for Sam or Letty, please input those questions on the chat box. It's just easier for us to track the questions, and we could address them as they come in. So we have someone that asks if you could discuss some alternatives to foreclosure. What options do lenders offer?
Sure. So every situation is actually different. A lot of loans are going to come with different rules around what they're allowed to offer. There's not really, or at least not anymore, there's not a set standard for every loan across the board. What really usually happens is a lender, when they're going to attempt to begin the foreclosure process, and let's say you have a conversation with them, they're going to require that you usually fill out an application. And this application is going to outline your financial situation. It's going to ask you for supporting documentation, like maybe a copy of some pay stubs, copy of your bank statements. It's going to ask you for a hardship letter. Amongst that, they might ask you for copies of tax returns. Once they get that application, they're going to run it through their own system. And that system is going to come out with the options, if any, and they're going to let you know there's going to be two sides. They're going to tell you there's a retention side, meaning these are the options that we're going to give to you, or that we're offering to you for you to keep the property. It could be in the form of a repayment plan. Maybe they have your normal payment is $1,000 a month, and they say we're going to have you pay $1,500 a month for the next 12 months to catch you up. If you can do that, your payments will return to normal. You'll be back to normal servicing. It could be a forbearance, the forbearance, and then the question is, after the forbearance, where's that money going to go? Is it going to be put on the back end of the loan in the form of a balloon payment? We don't know. So it really takes a lot of one-on-one attention, especially, and again, our unit, our department, our division within the department is really set up to do that. If you do end up asking us for assistance because you're not going to be covered by one of the new programs, or you haven't been in the past, that's what we would do. We would assign you to one individual foreclosure prevention counselor, reach out to the lender, help you go through the application, try our best to make sure that everything's set correctly, communicate with the lender, and make sure that everything that you had provided has been acknowledged by them and that they review you properly. It can be sort of a time-consuming process, but it's something that we're set up and we're specialized to do.
All right, thank you, Sam. We do have another question. How soon can a HOA foreclose for unpaid dues?
For that, it's if you owe up to $1,800 in dues, they can start a foreclosure. And I believe it's about a year as well. If you are behind in dues for up to a year and owe about the minimum of $1,800 in dues, then they can start to foreclose.
So does that follow the same procedure as a foreclosure of a mortgage? So do they file a notice of default and so on and so forth?
Correct. Yes. So the HOA will have to follow the California foreclosure process, which they will start with the first recording of the notice of default. And 90 days after recording the notice of default, then they would have to file the notice of trustee sale. When they receive the notice of trustee sale, it's going to explain to them that the property is going to be sold at auction, usually 20 days after receiving the notice of trustee sale. So we're talking about a total of 110 days for a foreclosure to be finalized. But with the HOA, remember, once the foreclosure is finalized, you still have an additional 90 days to redeem the property.
Thank you, Letty. We have another question here, and this is related to mechanics liens. So we have someone that would like to know if mechanics liens are treated the same or do they follow a different set of rules?
Well, I'll take a shot at this one. So I understand, and Clem, you can jump in at any time, but a mechanics lien is essentially the idea that somebody had recorded a mechanics lien against a property for not being paid after work they're claiming to have done. I believe you get the option to answer, and a construction company or whoever did the work has a certain time period to perfect the lien. So doing that, they would have to essentially go to court and sue you and get a judge to acknowledge that this work was actually done or not. After that, that lien would be placed. Whether or not I believe it's given the power of sale is going to be up to the judge.
Yeah, that's absolutely correct, Sam. And generally, there still will be a period where you can negotiate with the contractor. Also, to mention, it's not only contractors, but also a company that supplied materials for your project. So it could be someone that maybe supplied lumber or maybe a cement or any kind of materials to aid in the construction of either an addition to your house or actually the house itself or whatever the case may be. Okay. Yeah, I don't see any further questions. Again, if you do have a question, please feel free to enter it in the chat box. Also, Kevin, can you please go back to our contact page? Yeah, if you do have something that comes up or, you just didn't have the opportunity to ask the question, you may contact us at the toll-free number here, the 800-593-8222. Also, you can submit a question through our email, and that's homehelp@dcba.lacounty.gov. And I think no other questions. So we'll go ahead and wrap up the presentation. So thank you, Sam and Letty, for your thorough presentation on liens, lien position, priority, and foreclosures. If any of our participants or attendees know someone who's facing foreclosure or an eviction, the Department of Consumer and Business Affairs is here to help. Our services are free and confidential, and our well-trained staff can work with you and your lender to explore all your options. Thank you and have a good evening.